There we go.
Okay.
All right, we're going live in 3, 2, 1. We're live.
Good afternoon, everybody. I see that I have a number of people that have joined. My name is Sarah Cherry. I am a partner at Otten West Law. I am pleased to put this presentation on behalf of the MDTC membership. And I'm excited to talk to everybody about social media. This is something that has come up and continues to be an issue that judges and attorneys don't really know what to do with because it's new and ever evolving. And so when I was talking with Madeline from MDTC, we thought it would be a good idea to put this on, and it looks like there was a lot of interest in this as it continues to come up on a regular basis in litigation. So I won't try to keep everyone too long. Today I'm going to go through with a very broad brush some issues with social media, how to obtain the information, how to preserve the information, how to get private information, and ultimately use it in depositions and at trial. And I have Brianna Lukey joining me from my office. She made this presentation beautiful and put it together, and she will be flipping through the slides as well in case you hear me refer to her. If you have any questions, please put them in the Q&A below, and we'll go through everyone's questions at the very end. Brianna, we can go on to the next slide. Okay, this is just a little bit about me. So, you know, I have a little bit of experience in litigation actually doing this. I have been an attorney for about 8 years. I do medical malpractice defense, professional liability, and executive employment matters. I have dealt with the social media aspect on a number of occasions, and the times I've been in front of the judges on the issue, it seemed to be an issue of first impression with them. So this is a little bit of what I have found when I've gone in front of the judges, Court of Appeals on this issue. And I thought it'd be a good idea to share with everybody. Brandy, you can go to the next slide. Just a couple areas of practice for my law firm. As you see, we are in a number of areas. And like I said, it kind of gives us a broad brush in terms of litigation and all the areas that social media can come up, even in employment law, even in licensing issues. All right, so our agenda for today, we are going to talk about social media. So what is social media? Social media is an internet-based form of communication. It allows people and companies to express themselves, share information, communicate, share content, and have private conversations some of the times. In this presentation, I'm going to go through the different social media platforms, some of the issues that the platforms actually pose, including self-destructive data, how to actually preserve that data. There are times where you will have public accounts where people want to share everything with the whole world. There'll be other times where you'll find private accounts and need access to the information and how to do that. And then how to actually use the social media post and make sure that it's properly authenticated. This is, like I said, this is a broad brush, kind of hitting all the topics, but not necessarily getting into the nitty-gritty of every single aspect of this, as I'm not sure we have enough time in our lunch hour to do that. So going into the different social media platforms, I'm sure some of you are familiar with Facebook. That seems to be the very first one of social media. It evolved into Instagram, LinkedIn, Twitter, Snapchat, if some of you know that, and YouTube, Pinterest. Every day I'm pretty sure I hear about a new social media platform and I have no idea how to use it. Luckily I have some people in my office that really understand social media and the different platforms, and I am lucky enough that they teach me how to use them and share their TikTok videos with me. Okay, so in terms of websites, just as there's the different social media platforms, but there's also a website called Wayback Time Machine. I'm not sure if it exactly works on social media platforms like we would want it to, but just putting that out there, it is a way to understand if a website, I'm not sure if it's going to work on all the social media websites, but it shows you the changes over time. So sometimes it could be a link to something that someone posted on social media and whether the article they posted there changed over time. So it's just putting that out there, something that you can use as well as another tool. So starting with the social media, you need to get access to social media. How do you do, when do you do it, and why? So as soon as we get a case in the door, we find out as much information as we can about a potential plaintiff. We look at all their social media content. We go ahead, so we'll start with Facebook at the very beginning, and I'll kind of give you a broad brush and then we'll go through the tools for it. So we get a complaint in the door, we find the plaintiff's social media account, we completely download their profile so it's preserved. Then we send out a preservation letter, which I'll kind of go through in a second, asking the plaintiff's attorney to make sure that their client preserves all their information, specifically including social media. After the preservation goes out, we check on social media again, see if anything was taken down. If something's missing, we file a spoliation motion. And if we either find that the profile is private, then we'll send out social media requests. Sometimes even if it's public accounts, we send out social media requests so that we can find out if there's any other accounts that we may be missing. And I'll get into the fake accounts in a little bit, or multiple accounts. And then you also need to preserve the data the right way. And just because it's at the very end here does not mean it's the very last thing you do. You cannot just screenshot the data. You're going to lose all the data behind it, and you may end up with an authentication issue at the very end of it. So you might have the greatest piece of social media and ultimately cannot use it at the time of trial. So we'll get into that as well. You can go on to the next slide, Brianna. So you may think, why not just subpoena all the social media information? And I will say, good luck. We have tried it, and even in the face of knowing it was not going to be most likely successful, most of these companies are in Silicon Valley, of course, outside of our jurisdiction. It would take a lot to actually get to the courts there, a lot of your client's money, and ultimately you'll most likely be unsuccessful. They fight these things pretty hard. This is a sample letter. It doesn't look super official, but it is. It's the letter that the plaintiff's counsel received from Facebook denying the request, even though they sent the subpoena with a signed consent from their own client, and they still said, we're not going to give it to you. I would love to hear if anyone has actually been successful in subpoenaing any of the social media sites and actually getting the content back. And you can go on the next slide. So there are a number of ways to preserve the data. And I'll start by saying there are a number of forensic companies that can properly preserve data. And especially if it is a really important piece of social media, a really high damage case, you want to make sure that you get them involved really early on, even at the very beginning stages when you're doing that social media search. If you see the social media information out there, you want to contact them right away and say, I need this properly preserved so that I can use it later. And there are a couple of ways that we do in our office if we don't, go ahead and get them started at the very beginning of the process. There is the way to, just initially save it as a PDF. It's not as straightforward as it may seem, especially those that have very extensive social media presences. we will have to pull up the Facebook page, for example. You have to scroll all the way down because it has to load all the content, and it could be 300, 500 pages because some people have had Facebook since they were 13 years old, and they could be a very regular poster. And so if you do not scroll the way down, it will not properly save it. You cannot just hit print and expect everything to print out. It will not work. You do have to scroll the way down, and then you can follow the instructions that are on here to save it as a PDF. So at least you have some sort of backup copy of the entire profile. Like I said, you do not want to just take screenshots or print just one photo and nothing else, because you're not going to preserve the data that comes along with it or anything else that you may need later. Go to the next screen. So I initially started with preservation letter after you do the grab of the social media accounts that you can find online. This is a snapshot of what we include in our initial letters to the plaintiff's attorneys, and it's putting them on notice. We are going to be requesting this information. Do not have your client delete any information, put them on notice. We're, putting this duty on you, even though they have it anyways. But as you have mostly experienced, I'm sure, plaintiffs will go in and start deleting information once they believe that someone might be going in to get the information, or there's some sort of discovery request for that information. So preservation of data profiles, there are screen recorders. My office utilizes some of this information to record the screen as you're scrolling through the information. There are also video preservation apps that you can use, since it's a little bit more difficult to save videos that are posted on YouTube, Facebook Live, or videos that are posted on Instagram or elsewhere. And I believe that's on the next slide. It's the app friendly, but there's also other ones. And like I said, it's to preserve the videos. You don't want to just assume you can always go back to the link on the YouTube page or Facebook page. They expire at sometimes, or the plaintiff may delete the information once they know that you're looking at it, or you've brought it up, or you've requested social media information. Like I said, there are some issues with social media. There's Snapchat. I am not a user of Snapchat, but I've heard all about it, or Instagram stories. You can, and the whole purpose of Snapchat is to send information that will be instantly destroyed. It's self-destructive. It cannot be preserved. I've seen Snapchat videos pop up, and they have to be properly recorded. That seems to be an issue I have not been able to resolve or find out how to go back and obtain that data that might have been posted on there. You have to be careful not to, like I said, careful not to lose any of the data that is on the videos, and this unfortunately will destroy itself. Perhaps if you think that a plaintiff is a regular poster on Snapchat or Instagram stories with the intention that they always want the data to be deleted or self-destructed, then you can always then request to admit whether they intentionally posted information to be self-destructive. Most likely not going to be successful with that, as they'll deny it because it is self-destructive, and I'm not sure exactly how successful you'll be able to go back and grab that data at a later time. However, if anyone has experience with that, I would love to see it in the Q&A section, if you can let me know if you have any experience preserving that data. Okay, and then there are different things to do with public account versus private accounts. So let's say you are looking at a public account. First, it's not a one size fit all situation. You have to really understand the facts of the case. You have to understand your defenses. You have to look at the damages that they're alleging. You have to be able to kind of carefully go through the posts, know what to look for, what they were doing before the alleged injury versus after the alleged injury. The at issue time period, did they post when they're in the hospital? People tend to do that. People tend to post about the care they received after the fact, after they left, or any of the injuries that were symptoms that they experienced. People tend to want attention for these things, and so that is why they're posting all this online. There's also, look for posts that might have show you that there's deleted information. And we're going to get to a couple examples later, but I've had situations where we've sent the social media requests out. They go ahead and delete the information. And it's very obvious. If you look at the timestamps on the photos, you may see a missing gap of 6 months, and it's the exact 6 months that you need and you're looking for. We have been able to get access to a plaintiff's social media account to obtain that information and properly preserve it. And we filed a spoliation motion, and we were successful. So you just have to know what you're looking for and make sure that you're not missing any of that important detail, which we'll get into in the next couple of slides. Okay, so, of course, like I said, people want to post about all sorts of things, and especially when they're in hospitals, sometimes people will be looking for attention in that respect. This is a really good example. This was a case where a plaintiff was in a hospital and they're posting about the great care they received. And if you also need to start looking for family members that post about that person and their involvement with the plaintiff and all the things that they're saying about it. This one in particular, it was a post about how great the care they received. And of course, it ended up in a medical malpractice case. So it contradicts their actual claim in the case. Again, it goes along with the great care they received. And of course, in the case, they are alleging that the nurses or the hospital staff or providers were negligent, even though after the fact, they went in and thanked them by providing them with cookies. All right, other posts. People are posting about needing a lawyer, posting about why they think that someone messed up. Sometimes you might be able to extrapolate from that. Who told them that someone might have messed up? Did somebody else at a hospital say that? Another doctor messed up? It really provides you insight about what really initiated the lawsuit. Why did they think something was wrong? And so you just have to really closely look at the details of it so you make sure that you're not missing anything. These are a couple examples of when a plaintiff may stop posting because they got caught posting about things and it was brought up in a deposition, but their family members continue to post about their medical treatment, perhaps their functional progress or damages. And so, don't forget about the family members, especially those closest to them, especially the active posters. Keep going on their accounts on a regular basis, perhaps set reminders to remember to go back and check to see what additionally they have posted about the plaintiff. And always look at the comments. I know it sounds like a lot of work, but sometimes you may find some important information. In this particular situation, we found out that the plaintiff was back in jail at a very particular time in the lawsuit, and it became important. And this is how we knew to start looking and ordering the police records to find out a little bit more of what happened in the case. I mentioned earlier about looking for the gaps in time. And so the plaintiff, of course, went in, deleted a bunch of information or made some information private. And I used this information to say, hey, he's a regular, everyday poster. He's posting all the time. And yet, for some reason, there was this huge gap in time right at the time period that I requested in my discovery request. And the judge said, yeah, that doesn't look right, and gave me access to the plaintiff's social media accounts. Again, another post showing missing data, 2-month gap. Of course, when you're seeing missing gaps in time, it's a critical time, or something really important happened there that they're trying to prevent you from seeing. So again, pay close attention to that information. This is a post about a live stream video that we were able to preserve with some of the tools that we presented earlier. So you got to make sure that you're recording the video so that you can use it later on. There is a particular case that has an a claim for emotional distress related to the alleged injury in the case. and he's posting videos about his mental state and explaining what's going on with him. And as we can go through the post and the information, comparing it with some of the medical records, we can kind of start piecing that defense together as well. So again, make sure you're watching the videos, make sure you're regularly checking back up on the plaintiffs. GoFundMe pages. I know a lot of you guys are familiar with the GoFundMe pages. Perhaps there might be a collateral source issue here, as people are requesting money to go toward hospital bills or other things that they may be claiming damages for in the case. You might want to follow up, see how much money they received. Perhaps you can subpoena the records from GoFundMe. I have not been able to obtain that information. And those in particular that I was given no record statements from, the GoFundMe pages were a little bit too old. So you may want to send a subpoena, but you may also want to ask the plaintiff for how much money they received from the GoFundMe accounts. Okay, public accounts. This is information a plaintiff is putting out in the public. Surprisingly, not surprisingly, plaintiffs' counsels usually will claim that they are entitled to, the right to privacy, and that the information we are requesting or wanting to use is a fishing expedition, and that we should not be able to use it because it was on their private Facebook page, but it was publicly accessible. You may want to make sure that the page, just because there's a lot of information down on the page, does not mean it's wholly public. You need to look at the details of it and even treat it that it might be a private account, that there's data that's not on there. And you'll see it with my next post, but I'll stand here for a moment. There's also fake pages. So, and this is newer to me. I am trying to understand this a little bit more, especially younger people will have public accounts that their parents or employers can be on, check them out. They're a little bit more conservative posts, and then they have their Finsta, or there's another name for it. There's many names for it, but they have fake accounts so that they can post whatever they want to the other account without everybody having access to it. So just because you find an account doesn't mean it's the only account out there. You can go into the next one. Perfect. So private accounts, you may find a private account but not be able to access it, or you may find nothing and you can assume that they may be using another name. They may be using perhaps a maiden name. They may be using some other nickname so that people cannot access and find their accounts at all. So even if you don't find any account, still go after the social media information, send out the discovery requests. The plaintiff's attorney will most likely object to it. They're going to object that it's not relevant. They're going to object that it's a fishing expedition, it's overly broad, they have a right to privacy, and so on and so forth. I've never had a plaintiff's attorney just hand it over without a pretty big fight. And I think MAJ is very organized in that respect. So make sure that when you're filing your motions to compel for the social media content, that you are as detailed as possible. Why you want the information, what information you think is there, what information you have found, why you believe there's information, but you do not necessarily have to provide a basis saying that information's there. You just have a right to the information, you want access to it, especially in the day of a lot of judges not providing us with oral arguments. So we'll go on to the next slide. So of course, the court rules, MCR 2.302B1, it talks about why we get access to the information, what kind of information that we can have access to. Keep in mind that MCR 2.302B5 talks about a duty to preserve ESI. This is another reason why we send the preservation letter out. Plaintiff's attorney should already know this, but also make sure that you're reminding them of their duty to do so, that you can always use that preservation to say, hey, judge, we told them to preserve the information. We said exactly what we were looking for, and this information's gone, or they're not producing it, or it's been deleted. There's also the B6, which talks about limitation of discovery of ESI. It talks about a party need not provide discovery of ESI from sources that a party identifies as not reasonably accessible because of undue burden or cost. Well, that's another reason why you want to be more specific in your motion to compel, so that the judge can understand that there's going to be no burden to the plaintiff. There's going to be no cost to the plaintiff. The order, and we'll go into more specific order in a little bit, but the plaintiff can actually download the information themselves. Not that you want to necessarily rely on it, but there's some ways that you can do that with quite low costs. And you may want to, in your initial preservation letter, include a printout of the Facebook instructions to download that data. And then there's also the defense, of course, will pay for a forensic expert and be able to sit down with the plaintiff or their attorney, or the passwords can be provided to them with a limited time period, and they can sit down, properly preserve the data, and then the plaintiff can go ahead and change their passwords back. But again, it's not an undue burden and it's not an undue cost. And if there is any cost, the defense bears the burden of it. So specific discovery requests. These are some discovery requests that we used in the past. You can modify them a little bit to be more specific, especially if you have certain account information. Make sure that you include information. If you do know certain account names, make sure that they're providing you with all the account names. You can ask for the username and account, or you can ask them to, in a request to produce, to download the entire content of their Facebook page. Just make sure the requests are specific enough and that you can use it, because you will most likely have to file a motion to compel to get that data. And there's the other name for it. The fake accounts can be called burner accounts or Finsta accounts. Okay, so motion to compel, this is just a very basic one, kind of outlining a couple of the court rules, a couple of cases that you can use. But of course, this was before the changes in the Michigan court rules. But the idea and the concepts are the same. There were 2 cases that I had with different plaintiff attorneys, and I got similar orders in each of the cases in Wayne County, different judges, granting my motion to compel for the social media information. The orders were a little bit different on each one of them. The plaintiff attorneys in these cases hired the same appellate attorney, and they filed an appeal. Ultimately, their appeal was not granted, and the plaintiffs had to produce a social media information. If you take a look at the sample orders, you'll see that they were limited to a time period. The pertinent time period, it might be information including data before the alleged injury, after the alleged injury, or even for a certain period of time. You should, in the proposed order that you attach the motion to compel, it should include what type of data you're looking for. Are you including just all posts, videos, articles that are shared? Are you looking for the messages on all of these social media accounts? There's private messaging on each one. The plaintiff may have more of an argument in terms of privacy, even though there's no privilege there. So you have to be very specific about what you're looking for and why. In a couple of these orders, we have a forensic analyst involved to be able to go in, download the data the right way so they can be properly authenticated later on. Take a look at the language in the orders, but you'll need to make sure that you tailor it for each case, and especially that make sure that you give the judge a reason to actually grant your motion. And just more information in terms of what was argued on the appeal and the order from the trial court, with a very specifically tailored set of information, so it does not provide a complete all access to plaintiff's social media account all the time. It's limited in that respect, and limits the defense attorney from not being able to go in themselves and access the information, but instead having an expert that is properly trained and able to do it and has limited access to the information. All right, so you went through all of those steps and got the social media information. Now what do you do with it? Okay, and this is another reason why you want potentially forensic analysts involved. They can go in and properly get the data. Keep in mind the authentication issue. that you're going to have in cases potentially. This is why you want to make sure you are properly authenticating documents. You perhaps can get the plaintiff to agree that it was a certain social media post. And you'll kind of see in a couple of the other slides about, they were asked about the social media post. It was marked as an exhibit. That exhibit can be used at the time of trial, and that the plaintiff already authenticated that that was something that they posted, or you will need to have an expert witness in to authenticate the data that they downloaded from the plaintiff's account. You'll always need to be cognizant of the issue that a lot of times when someone posts something on social media that they regret, or it comes up later and kind of bites them in the butt, that they claim that they were hacked. So make sure that you have all your social media information together before the deposition of the plaintiff, if you can. There's also the correlating federal rule, FRE 902. Just make sure you're taking a look at that as well. But the Michigan core rules, as you know, especially rules of evidence, mostly mirror the federal rules. So going on to the deposition of a plaintiff, this is where you are looking at their social media posts, you're getting information about them. They may claim that they are not able to get a job. They may claim that they cannot work because of the alleged incident, and yet they are posting about it online. And so you want to make sure that you have those posts available to use at their deposition. And again, to make sure that you're marking them as exhibits to authenticate them. And again, these are more examples of all the information, especially things that are at the very heart of your case and key to your defense, people are posting online as a part of their social media. And they assume that that information is not going to be found, even though it directly contradicts the information that they may be claiming, or perhaps their life care planner is claiming in their case, or in their life care plan, or saying that they need certain devices, or they are not able to do certain things. They will post that on social media. So just make sure you're looking out for the details, watching the videos as well. And this is just an example of being able to use the information in a life care planner expert deposition about using the information that the plaintiff has represented on social media versus the information that the plaintiff presented to the life care planner when they sat down together. So again, you are able to use the same data both in the deposition of the plaintiff as well as experts, and perhaps even other damage experts or causation experts outside of the life care planner. Again, look out for the videos. They may post videos. And this was a particular example about a video being posted doing a very complex task that the life care planner indicated that the plaintiff was unable to do due to the injury. Just another example of information that you find on different social media sources that you can use in a deposition. Okay, and this happens to be very unfortunately, this was another video that was found on a partner of a plaintiff, and the plaintiff was also involved in this video but not pictured, and it shows that they were using weapons around children, and it's actually very pertinent to the claims in the case. So again, look out for the videos of family members or friends of the plaintiff as well. This is another post about looking at a spouse's page, making sure that you're regularly looking at their information. This is a situation where a plaintiff claims that he was unable to work, yet even his spouse, although the spouse testified that he was unable to work, is posting information about him being able to go back to his pre-injury duties. And of course, after the deposition of a plaintiff, make sure that you are going back, checking the page, seeing if the page went private, seeing if any information is being deleted, and continuing to check up, especially when their guard is down. And perhaps you may want to take a look at this information before you may involve private investigators or anybody else. Again, make sure your data is always preserved, especially if you're finding things right before the time of trial, as they've most likely let their guard down and kind of a little bit more free to post information online. And again, I said check social media several months before. Again, this might be information that you want to provide to any damage experts that might be testifying at the time of trial as well. And so I would love to hear if anybody has any social media orders with judges compelling the production of social media, how they were compelled. If anybody has any motions that were successful, I would love to see them, and I can kind of gather them and send them out to the membership. Does anybody have questions at this time? I will pause in awkward silence if anyone wants to put anything in the Q&A post below. And Brianna, you can just go to the next slide and let that slide there. Okay, and I actually have a great comment, and and I don't want to say the name wrong. Zabia Al-Hulu, as for self-destructive data, I would use another phone to record those videos step by step from the calendar to open the app until the video. And so that's a really good piece of advice, is using another phone to record it. The only, it's something, it's you have the data there, you're going to have it recorded. You're going to lose the metadata behind it for authentication, but if you can record the data, if you can perhaps get a plaintiff to verify the data that you were able to preserve, then I think you're going to be in a better position that way. There is a question, has anyone filed an MTC Facebook data in Kent County? And there was also a question, are paralegals using their own personal accounts to look into plaintiff social media? Great question. One of my points I think I must have skipped over earlier, you should make sure that you have a dummy account. Make sure that you're not using your account, anyone from your office account, as the information may show up that, especially on LinkedIn, will show you who's searching it, or it will show you or post as one of the potential friends that they might want to add to social media. You want to make sure that you or your office is not being associated with any searching of the social media accounts. That was a really good question. Going back to the self-destructive data comment, Zabi Alui, also, if you screenshot any Snapchat or Instagram stories, the plaintiff will get notification of the screenshot, so you might want to use another person's account. Okay, and that, again, that's a good reason to have maybe a dummy account for your entire firm, or you might have a female dummy account, a male dummy account, depending on whose information you're looking at. There is a question by John Mucha, who are the leading consultants that help attorneys mine this information and preserve it in an admissible form? Great question. I have used a couple of forensic companies. Someone who seems to be really on top of this is Michael Huntsman. And Brianna, if you go to the next slide, his information, cross-examination investigations is there. And I can provide his information when I send anything out after this. He sent me a presentation that he did a while ago regarding more of the federal issues. He seems to know exactly how to properly preserve the data, and I think he would be a really good point of reference. His company seems to do this, and he's a great supporter of MDTC. All right, and I have a question. Let me see if I can pull this up here. From Brooke Johnson, when you ask for access to social media, do you directly ask for plaintiff's passwords, or are you requesting the data download from the site? It depends. And so I will ask for the passwords and account names in the interrogatories, or alternatively, I'll ask for a download. However, with the download, it's great to get it from the plaintiff. However, you may want to follow that up after you actually get the information with requesting that a forensic analyst get access to the Facebook account so that they can download the data and it can be properly preserved and authenticated. The data that comes over a download is complicated. I myself am not a huge IT person. I can kind of sort through it, but to actually make sure you have the proper data for use later on and making sure that you don't have any authentication issues, you will want to get an expert involved. And that's usually where you'll want to get an order from the court saying, allowing your forensic expert access to the information. As you'll see in one of the orders I had up, the judge allowed my forensic expert to have access to the information. The plaintiff was allowed to change their password after a certain period of time, but after that, during the time frame that they had access to the account, the forensic expert could actually go in and download it the same way the plaintiff was able to do so, just to make sure nothing was deleted and it was properly preserved. Any other questions? I want to make sure I'm not missing anything. I'll pause for a couple minutes to make sure that I'm not missing anything. Oh, Brianna, you can go to the next slide. Anyone else? Again, I'll just give it a minute if anyone's typing. Well, while I'm waiting to see if any other questions pop up, I would like to thank Brianna Lukey from my office. She put together this wonderful PowerPoint. Our firm's very own nurse paralegals who are great at going on plaintiff social media accounts and really tracking down the right information, friends and family, regularly checking back on the social media accounts. Also the support of my partners and all the staff here at Aughton West Law. Special thank you to MDTC and Madeline Lowry and Matt Hinkle for making this happen. And also a special thank you to Michael Huntsman from Cross-Examination Investigations, as he was a great source of information as well and helped walk me through a little bit more of the technical aspects of everything. Any other questions before I end? Oh, perfect. All right, everyone. Thank you so much. I appreciate everyone for your time. If you have any questions or have any social media orders or anything else to share, please send it to me. I sent you the PowerPoint presentation. You can just respond to that email. And if I get a bunch of good information, I'll send it out to the MDTC membership. Thank you very much, everybody. I appreciate it.